The first afternoon session focuses on maritime law, and please join me in welcoming Professor Nishimoto. He's a professor at Tohoku University, and he's a specialist in the law of the sea, especially on the settlement of maritime dispute, as well as the sustainable development of ocean resources. Today, he will discuss with us the law of the sea and the territories. Please join me in welcoming Professor Nishimoto. Sensei, よろしくお願いいたします。
Good afternoon. I hope everyone had a good lunch and had some fresh air outside. My name is Kentaro Nishimoto. I'm from Tohoku University, which is a university in the northern part of Japan. And the topic for the first topic for this afternoon is the law of the sea and the law of territory. And a commonality of the two fields is that they both relate to how the world is spatially ordered through the lens of international law. And as I will also be explaining in this lecture, I think another significant aspect of the two fields is that the jurisprudence of international courts and tribunals have played a very significant role in the development and also the implementation of the law. So in this lecture, it seems that I do have two areas to cover. So I plan to provide a very brief overview of the law of territory and spend the rest of the time on the law of the sea, discussing both basic features of the regime and some recent developments which is leading to the further development of the law in this field. So our first topic, the law of territory, concerns the physical aspect of the state, of course, which is the basic unit of the international legal system. The state, of course, occupies a certain territory, and how this territory is acquired, transferred, and how territorial disputes are resolved are the main issues in this field of international law. And the key concept in this field, as you may all be aware, is the concept of a title to territory, which can be said as the source of territorial sovereignty under international law. And so when the state is said to have title to a certain territory, the sovereignty of that state over that territory is legally justified. And other states are required to recognize the control of that state over the territory in question. The rules relating to title to territory in international law is regulated by customary international law rather than treaty-based rules. And if you consult any textbook on international law, it is usual for them to start with the explanation that there are certain modes of acquiring acquiring title to territory. However, very interestingly, and if you have studied international, you might have found it very curious, the explanation always comes with an observation that this approach of focusing on the modes, which stems from analogies based on Roman law, is not really adequate in its ability to be applied to modern territorial disputes. But we do have what are called the classic modes of acquiring title to territory, which are explained to be what we have on the slide: occupation, accession, cession, subjugation, and prescription. Occupation, of course, is a method of acquiring title to territory through the effective possession of terra nullius, which is a territory which does not belong to any state. Accession is a process of an increase in territory through the formation of new territory by natural or artificial processes. This can occur, for example, as a result of maybe a deposit of sand in a river mouth, or volcanic activity that has happened in the case of Japan, or by reclamation of land. Cession is a method of acquiring title to territory by an agreement in a treaty, and subjugation is a method of acquisition of territory by conquest followed by annexation, which was discussed as a legitimate mode of acquiring title, of course, before the prohibition of use of force in international relations. And while it should be obvious, I think it's still worth mentioning, given the present circumstances, that the acquisition of territory by the use of force is strictly prohibited under international law today. This is a logical consequence of the prohibition of the use of force and also the threat of use of force under Article 2.4 of the UN Charter. And this understanding is, of course, also confirmed in the Declaration on Principles of International Law concerning friendly relations and cooperation among states, which was adopted by the UN General Assembly in 1970. The declaration states specifically that the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force, and further that no territorial acquisition resulting from the threat or use of force shall be recognized as illegal. And if we are to go down the list, finally, prescription referred to the acquisition of other states' territory based on a persistent and unchallenged possession. But in contrast to the classic modes of acquiring territory, which focuses on whether a state can establish a certain fact as a valid title to territory, international courts and tribunals, when considering a territorial dispute, has adopted an approach that compares the relative strength of the arguments of the disputing parties. Of course, the classical modes can still be regarded as a valid understanding under international law, but since actual territorial disputes usually involve a very complex set of facts extending usually over a very long period of time, it is difficult, if not impossible, to resolve a dispute solely on the basis of the application of the classical modes-based approach. And when we actually start considering how the International Court of Justice has approached territorial disputes, it is evident that the court follows a fairly standardized approach in considering which state has sovereignty over the territory in question. The court will first consider whether there is an agreement between the parties establishing the title of a state over the territory in question, such as we have on the first point on the slide, such as by a boundary agreement. And when it is established that the disputed territory is addressed by a specific treaty, the court will make its determination based on the treaty-based title. However, if the title cannot be confirmed, the court will base its decision on the relative strength of the claims, focusing on the effective administration of the territory in question. And in the jurisprudence of the International Court of Justice, such effective administration is usually referred to using a very specific term. The term is effectivité. The acts by a state which can be considered as an act of sovereign in the form of exercising legislative, administrative, or judicial functions are considered to constitute effectivité. And the focus on this administration, effective administration of territory, has its basis in the understanding first indicated in the island of Parma's case that the peaceful and continuous display of territorial sovereignty is good as title. And in practice, the court has made findings on territorial sovereignty in accordance with the approach based on fairly relatively scarce effectivité. For example, in the case concerning Pulau Ligitan and Pulau Sipadan, the ICJ acknowledged that in particular in the case of very small islands, which is uninhabited or not permanently inhabited, effectivité will indeed generally be scarce, but that did not stop the ICJ from reaching its conclusion on the basis of the comparative strength of effective administration. So I think from all this we can say that while territorial disputes are usually fraught with factual and historical complexities, the legal framework in which a state's sovereignty to a certain territory is considered can be said to be fairly clear. And in addition to this basic approach, mention needs to be made of some other rules and principles which are often invoked in territorial disputes before international courts. The first two involves how the element of time is dealt with in the process of considering a territorial dispute. The doctrine of intertemporal law relates to whether the law prevailing at the time of the fact in question should be applied or whether the law as they exist today should be applied. And on this point, it is the established understanding that the facts in question must be assessed in light of the rules that existed at the time rather than as they exist today at the time of the adjudication of the dispute. Therefore, the validity of the acquisition of a title is considered in accordance with the law that existed at the time of the acquisition. The concept of the critical date refers to a specific date within the overall dispute, which is considered to be particularly relevant for the territorial dispute in question. And courts have indicated in many cases that they will not consider acts after the crystallization of the dispute between the parties. And the main reason for this is that there may be acts which have been conducted solely for the purpose of improving the legal position of a party after the parties have become very aware that a dispute has arisen between them. However, if we look at the actual practice of international courts, it seems to be the case that there is a discretion of the court on how and whether such dates will be set. And in practice, how this issue is dealt with depends on very much the factual circumstances of the case. I think it also goes without saying that the attitudes of states in relation to contested territory may play a certain role in how a state's title to a certain territory is determined. I have on the slide three words: recognition, acquiescence, estoppel, but they are often invoked in favor of a state's territorial claim. And combined with other circumstances, facts that can be construed as amounting to acquiescence or estoppel can actually be very decisive in courts' determination of the sovereignty over a territory. And in cases involving the obtaining of independence, especially in a colonial context, the principle of uti possidetis juris is often invoked and applied. The principle requires states to respect the intangibility of frontiers inherited from the colonial powers. The ICJ, for example, in the frontier disputes case between Burkina Faso and Mali, indicated that this principle is an established principle of international law, and that despite its origins in South America, this principle is not regionally limited in its application. Although there are other issues to discuss on this topic of the law of territory, and it might be beneficial to maybe even go more deeper, looking at some actual cases, unfortunately, in the interest of time, I would like to move on to the second part of the lecture, which will focus on the law of the sea. And the law of the sea is a rather big area of the law. And so I was sort of wondering what would be the appropriate approach to adopt here. Obviously, I cannot explain the whole area, but I thought it might be too much for some participants, if you're not really familiar with the law of the sea, to just go to the recent developments without explaining very much about the basics of the law of the sea. So I've chosen a kind of a compromised approach. So I will first introduce you to what I consider to be one of the most important features of this body of law, focusing on the allocation of rights and jurisdiction between states in the law of the sea. and also the existence of a compulsory dispute settlement mechanism. Then after that, I would like to discuss some recent developments in the law of the sea. And the key issues, I believe, are how the rules and principles of the law of the sea have been put into practice, and also how the law of the sea has and continues to respond to new circumstances. And I think how the international law of the sea has been evolving is rather remarkable when we consider that the basic rules and principles in this field is set down in a treaty that was adopted more than 40 years ago. And in discussing the law of the sea, I think it's very useful to think of the law as serving two distinct functions. And one of the basic functions of the law of the sea, I believe, is to allow states to conduct activities at sea in a peaceful and orderly fashion. And one way in which international law can contribute to the avoidance of disputes in international relations is to provide clarity on the extent of rights, jurisdiction, and obligation of states with regard to a particular issue. And when it is unclear to what extent states have different rights, jurisdiction in a certain place or regarding a certain activity, there may be room for overlaps. And if you have overlaps, they tend to escalate, perhaps in certain situations, into disputes. On land, if you think about what happens on land, states are kept peacefully apart basically by drawing a clear boundary between their territories. Of course, there may be territorial disputes in unfortunate situations, but basically the understanding is that the state has a clearly defined territory. And the boundary is a good mechanism to keep states peacefully apart. However, the law of the sea adopts a very fundamentally different approach in dividing or allocating rights and jurisdiction between states. And I think this element is what is very important to understand in this field of international law. And the reason that the law of the sea adopts a different approach, I think we can identify different reasons. One may be that the ocean is very vast. States were not able to divide the space among themselves, unlike on land. And of course, there is also the need to be able to use this space for navigation and commerce in the interest in the common interest of the international society. So the allocation of rights and jurisdiction between states is one very important aspect of the law of the sea, which I will turn briefly. However, there is another function which is actually becoming a very important aspect of the law of the sea, which is to establish a legal framework for cooperation in managing the oceans. And issues such as the protection of the marine environment and the conservation of biodiversity are issues that can only be addressed and solved through international coordination and cooperation. And I think there is now a really great realization that the oceans must be properly managed to ensure their conservation and sustainable use. And it is the law of the sea that provides a legal framework for such ocean management by being able to require states to adhere to specific obligations relating to the protection of the marine environment. And on this aspect of the law of the sea, I will touch on some of the relevant issues in this section on recent developments, which will be in the later part of this talk. And in contrast to the law of territory, which is primarily based on customary international law, I think it goes without saying that our discussion on the law of the sea will be mainly treaty-based. The most important treaty in this field is, of course, the United Nations Convention on the Law of the Sea, often referred to as UNCLOS for short. It is a multilateral treaty with 169 parties. I think we could regard it as a very successful multilateral treaty. And it sets down rules relating to the law of the sea in a close to comprehensive manner. How the UNCLOS is viewed by states, I believe is reflected in the annual UNGA resolution on the oceans and the law of the sea, which describes UNCLOS, and as I have the actual text on the slide, which describes UNCLOS as the legal framework within which all activities in the oceans and seas must be carried out. The rules contained in UNCLOS, particularly those on zonal regimes, are considered to reflect customary international law and therefore are also binding on non-parties. And so regarding the allocation of rights and jurisdiction to conduct and regulate activities at sea, UNCLOS adopts a dual approach. The first approach is the regulation of ships by flag states. And of course, this approach is very effective because human beings cannot really do very much without resorting to ships. There is a basic principle known as the principle of flag state jurisdiction, which means that ships are subject to the jurisdiction of the state whose flag it flies. And this principle ensures that flag states exercise control over their vessels, and that order at sea is maintained through the control of flag states. This principle also reflects the freedom of the sea by ensuring the right of navigation against interference by other states. The second approach is the regulation of activities according to different maritime zones. And so in other words, in the law of the sea, different sets of rules and apply to the different maritime areas. Traditionally, if you look at the history of the law of the sea, there was this big dichotomy between the territorial sea and the high seas. And under this traditional regime, coastal states could exercise powers over a fairly narrow belt of the territorial sea along their coast. But beyond that zone, it was the high seas, which was left to free use by all states. However, in the development of the law of the sea leading to UNCLOS, complex regimes were created to accommodate different interests for different uses of the oceans, such as navigation, development of mineral resources, fishery resources. Of course, we have more newer modes of using the oceans as well. So this diagram is a diagram that I made for my course on the law of the sea in my university, and depicts the different zones reflected in UNCLOS. And as I mentioned at the outset, although time does not allow for a complete explanation of the legal regime of the different maritime zones, one thing that I would like to highlight is that the balance between different interests in the different uses of the oceans, and in particular navigational and other uses, is the key to understanding the legal regime of maritime zones under the jurisdiction of the coastal state. So this applies to the territorial sea, and although I don't have it on the slide, archipelagic waters, the contiguous zone, the continental shelf, and the exclusive economic zone. And a significant element of these zonal regimes in UNCLOS is that a balance is struck by allowing certain powers to be exercised by coastal states while allowing certain powers to be exercised by other states in the same maritime area. So as I have been emphasizing, this is a very different approach to the system that we have on land. And if we go to first the legal regime of the territorial sea, there is a clear understanding that the territorial sea is under the sovereignty of the coastal state. So to that extent, the applicable legal principle is the same as territory on land. However, in the law of the sea, other states have the right of innocent passage, which allows states to navigate through the territorial sea of a foreign state, provided that such passage is innocent. In practice, since we have this regime, a critical point for the balance between the interests of coastal states with regard to maybe national security and other interests, and the interest of other states with regard to navigation, is the concept of innocence. So since we have this regime based on a certain balance, and sort of the tipping point of the balance is innocence, it is a big issue under the law of the sea what this means. And for that reason, of course, we have Article 19 of UNCLOS. We have a definition, what seems to be a definition of innocence. But states adopt different interpretations, unfortunately, of this article. Some states take the view that the generally formulated paragraph 1, generally formulated standard in paragraph 1 of the article, which is, if you can just look at the small text, I'm sorry, which is whether the passage is prejudicial to the peace, good order, or security of the coastal state. So the question is whether that is the controlling criterion for innocence, because some other states maintain that paragraph 2 is more significant in identifying what is meant by innocence. And for those states, paragraph 2 of the article is an exhaustive list specifying in detail the activities that are considered to be prejudicial to the peace, good order, or security of the coastal state. So it's a question of whether we should apply the general criteria in the first paragraph, or whether we should regard the contents of paragraph 1 as being laid out in paragraph 2, and that whether a passage is innocent should be considered in accordance with the actual list of activities in paragraph 2. So since this is a regime based on the balance of interest, and since there is a criterion of innocence, these kind of issues can become an issue of interpretation, and can in some cases lead to very different views being adopted by different states. Now, after discussing the territorial sea, I would like to move on to the legal regime of the exclusive economic zone. And I think understanding this regime is actually very key to understanding the law of the sea. And the sovereignty of the coastal state in the territorial sea is limited only in relation to the right of innocent passage. But in the exclusive economic zone, the EEZ is a zone built on a further balancing of the interest in different uses of the oceans. And according to Article 55 of UNCLOS, the EEZ is subject to the specific legal regime established in this part, which is referring to Part 5 of UNCLOS, which sets out the legal regime of the EEZ. And what this article is doing is that it makes clear that states have rights and obligations in UNCLOS only because such rights and obligations are given to them under UNCLOS. And also, I think we could add that the rules also now are considered to reflect customary international law. So in this way, how everything is structured is completely different from territorial sovereignty over land, or even compared to the legal regime for the territorial sea. Because for the territorial sea, certain rights, even if it's not provided in UNCLOS, could be derived from the territorial sovereignty that coastal states have, provided that such rights are consistent with the existence of the right of innocent passage. So there is a kind of a principle to fall back on if the area in question is regarded as falling within the sovereignty of the coastal state. But the situation is completely different in the exclusive economic zone. And this was crucial to the compromise which was achieved in the Third United Nations Conference on the Law of the Sea. So Article 55 makes it very, very clear. And with now looking at the specific rights of coastal states in their EEZ, Article 56 lists the rights and jurisdiction that coastal states may exercise in their EEZ. And the most important right is the sovereign rights for the purpose of exploring, exploiting, conserving, and managing the natural resources that exist in the exclusive economic zone. And at the same time, according to another article, Article 58, all states are recognized the freedoms of navigation and overflight, and of laying of submarine cables and pipelines and other internationally lawful uses of the seas related to these freedoms in the EEZ of other states. And also recognizing that the exercise of rights by coastal states and the exercise of coastal states by other states in the EEZ may affect one another, the rights come with an obligation to have due regard to the other states' rights. This is set out in Articles 56.2 and 58.3. So Article 56.2 says that the coastal state shall have due regard to the rights and duties of other states. On the other hand, Article 58.3 provides that all states shall have due regard to the rights and duties of the coastal state. So this is a mutual obligation of having due regard to one another. Of course, this may seem like a very good balancing criterion. However, there is an issue that the obligation to have due regard is rather difficult to pinpoint in clear terms. So what does it mean? What could you do to say that you have definitely complied with this obligation? The arbitral tribunal in a certain case, the Chagos Archipelago Marine Protected Area arbitration, indicated that in the context of that case at least, the extent of the due regard will depend on the nature and the importance of the rights and activities, the anticipated impairment of the rights, and also the availability of alternative approaches. And it was also added that in the majority of the cases, the balancing assessment will necessarily involve at least some consultations with the rights holding state. So this is a kind of a concept which reflects the need to have consultations to achieve a certain balance between the interested states. And so the formulation of the EEZ in this way served as a compromise between states that wanted wider territorial seas due to resource-related interest and states that oppose such claims due to different reasons, such as the impact on navigational rights and freedoms. So the states realized that they could have both if they could find or if they could establish a legal regime that accommodates both the interest of coastal states over resources and the interest of other states in the navigation of the area. So that is why we have this rather complicated regime, which is very different from what we have on land. However, in practice, of course, if you have this kind of complex regime, it's very difficult to implement. We can have difficulties in, for example, identifying specifically which activities are subject to regulation by coastal states and which activities are left to be freely conducted by other states. So there may be certain situations, and actually there are certain situations, where states have different views as to whether a certain activities falls within the scope of the sovereign rights and jurisdiction of coastal states under Article 56, or the freedoms of other states under Article 58 of the Convention. And the legal nature of the EEZ, which is to accommodate different uses, could be a source of instability if we did not have a way to reach a common understanding on the interpretation and application of Articles 56 and 58. And one example of such a situation, I will try not to bore you with these general observations. Maybe we should go a little bit more into actual cases. And one example of such a situation is a dispute regarding the regulation of bunkering activities in the EEZ. The term bunkering refers to the act of providing fuel to be used by other ships at sea. So it's like a gasoline station operating at sea. And the question of whether coastal states have the power to regulate bunkering activities in the EEZ was actually raised in two cases before the International Tribunal for the Law of the Sea. And although the issue in itself may not really sound interesting, it does raise interesting theoretical questions about this regime of the EEZ based on the balance of interest. So the specific question in the two cases were the following, what is stated on the slide. So if a tanker sells and transfers fuel to another ship, which may be a merchant ship or fishing vessel in the EEZ, does the regulation of such an activity fall under the power of the coastal state as maybe an exercise of sovereign rights or an exercise of jurisdiction by the coastal state, or does it fall under the competence of all other states maybe we could characterize it as an exercise of the freedom of navigation, or there is also another term that is contained in Article 58, which is other internationally lawful uses of the seas related to these freedoms. And the answer to this question actually is not really immediately clear if you think about it. Bunkering is an economic activity. It's different from activities directly aimed at exploitation and explorations of the resources. It's not about resources because it's about commercial activity. On the other hand, it's very different from simply navigating through the EEZ because it is a commercial activity that is conducted in the EEZ of another state. So the first dispute that was brought to the ICJ is now a fairly old case, the MV Saiga case, which was decided in 1999, which concerned a dispute between St. Vincent and the Grenadines and Guinea. The Guinea was the coastal state in this case, and Guinea arrested an oil tanker named the MV Saiga, which was flagged to St. Vincent and the Grenadines at a point about 22 nautical miles from the nearest land. Therefore, the location of the arrest of the Saiga was beyond the territorial sea of Guinea and in the exclusive economic zone of that state. And the main charge against this vessel was that it had illegally imported gas oil into the customs radius zone of the coastal state. And it appears that according to the domestic law of that state, unauthorized import of gas within 250 kilometers of the coast was strictly prohibited. And the main question in this case was whether a coastal state is entitled to regulate this ship, which was conducting certain activities on the basis of the domestic law of the state. And the argument on behalf of the flag state was that the extension of the customs laws to the EEZ was contrary to UNCLOS because Article 56 does not give such powers to coastal states. And the decision of the tribunal in this case was rather straightforward. The tribunal stated that it needs to determine whether the laws applied and measures taken by Guinea against the Saiga are compatible with UNCLOS. And in the words of the tribunal, in other words, the question is whether under the convention, there was a justification for Guinea to apply customs laws in the exclusive economic zone within a customs radius extending to a distance of 250 kilometers from the coast. And in this regard, the tribunal first noted that coastal states are entitled to apply customs laws and regulations in the territorial sea and to exercise certain powers in relation to their customs laws and regulations in the contiguous zone. However, if it is in the exclusive economic zone, the coastal state has only jurisdiction to apply customs laws and regulations with respect to artificial islands, installation, and structure. So there is a little bit of basis to apply customs laws to a rather specific small area in the exclusive economic zone. But the conclusion of the tribunal was that the convention does not empower a coastal state to apply customs laws in respect of any other parts of the exclusive economic zone. And we can see that the tribunal addressed this case as a case concerning the application of customs laws and regulations to activities conducted within the exclusive economic zone. And based on the provisions of UNCLOS, the tribunal simply concluded that there is no such competence under Article 56. So everything seems to be fairly straightforward. However, in reaching this conclusion, the tribunal was rather cautious in its judgment. The tribunal stated that what needed to be decided in this case was whether the actions taken by Guinea was consistent with the applicable provisions of UNCLOS, and that it is not making a finding on the more general question whether coastal states have rights to regulate bunkering in the exclusive economic zone in general. However, one issue that could have been asked is whether the outcome for the coastal state would have been different if it was able to invoke other grounds for regulating bunkering. For example, maybe how about management of living resources or the protection of the marine environment. Maybe if we transfer oil from one ship to another ship, there may be a spill, there may be concerns about the protection of the marine environment. the jurisdiction over the protection of marine environment in the EEZ is something that coastal states have under Article 56. So while it was clear that the coastal state did not have any rights concerning the application of customs laws in the EEZ, there was still the possibility that the conclusion might be different if the facts of the case was a little bit different and the activities were in relation to one or maybe more of the rights or jurisdiction that coastal states have in the exclusive economic zone. And then there was another case which was decided in 2014. The Virginia G case, which is also the name of a ship, was decided in 2014, and it was actually specifically that kind of case. This case was another case concerning bunkering, but interestingly in this case, the coastal state had enacted regulations that applied to bunkering because of their impact on the management and conservation of the living resources of the exclusive economic zone. So this time it was not about customs. It was about concerns that if the fishing vessels can be refueled at sea, that may lead to longer fishing periods, and that may have an impact on the efficiency of the fishing vessel, which may lead to overfishing. Therefore, the coastal state thought that we need to have regulation on the bunkering of fishing vessels. So the facts were slightly different, even though the two cases were both about bunkering. And in this case, the tribunal first observed that the term sovereign rights, in the view of the tribunal, encompasses all rights necessary for and connected with the exploration, exploitation, conservation, and management of natural resources, including the right to take necessary enforcement measures. And the tribunal then emphasized that in the exercise of the sovereign rights of coastal states to explore, exploit, conserve, and manage the living resources of the EEZ, the coastal state is entitled under the convention to adopt laws and regulations establishing the terms and conditions for access to foreign fishing vessels to its exclusive economic zone. And in this regard, the tribunal cited Article 56, paragraph 1, which is an article that we've been referring now often, but also to Article 62, paragraph 4, which is a provision which sets down in detail the power of coastal states to adopt laws and regulations with respect to fishing in the exclusive economic zone. And on the basis of that, the tribunal then stated that, as I have it highlighted on the slide, it is apparent from what is provided in Article 62, paragraph 4 of the Convention that for all activities that may be regulated by a coastal state, there must be a direct connection to fishing. The tribunal observes that such connection to fishing exists for the bunkering of foreign fishing vessels in the exclusive economic zone, since this enables them to continue their activities without interruption at sea. So the conclusion of the tribunal in this case was completely opposite of the conclusion reached in the MV Saiga case, even though both cases were about bunkering activities in the exclusive economic zone. So the approach adopted in this case, consistent with the approach that was adopted in the MV Saiga case, was not to consider whether there exists a right to regulate bunkering as a type of an activity in the abstract, but whether specific legislation in question can be justified in light of the provisions of UNCLOS concerning the rights and obligations of coastal states in the exclusive economic zone. The tribunal considered the legislation by Guinea-Bissau, which was the coastal state in this case, on bunkering as a regulation concerning fishing-related activities, even though the regulation or the act to be regulated was not fishing itself. So in the view of the tribunal, the law could be seen as justifying the exercise of sovereign rights of coastal states under Article 66 over bunkering activities conducted with respect to fishing vessels. And the approach adopted in the two judgments indicate that whether the regulation of activities that in the EEZ falls within the competence of the coastal states is to be considered in light of whether it can be justified as an exercise of coastal states' rights and jurisdiction under Article 56. So now we come back to the idea, which of course was embodied in Article 55, that this regime is about whether certain rights or obligations are provided to specific states under the convention. Of course, this does not mean that maybe coastal states can regulate any kind of activities if they can maybe come up with a persuasive argument, perhaps even in an afterthought, that such powers can be explained in connection with sovereign rights or jurisdiction that coastal states have in the EEZ. The tribunal in the Virginia G case actually considered the legislation of the coastal state in detail and actually confirmed that the purpose of the law was to indeed regulate the adverse effects caused by bunkering activities to the management of living resources in the exclusive economic zone. And in this connection, the tribunal did not actually address the possibility of justifying the legislation based on the jurisdiction with regard to protection and preservation of the marine environment, and simply stated that the regulations of bunkering were incorporated in legislation on fisheries. So the tribunal was actually looking at what the legislation were really about. So if coastal states come up with a kind of an afterthought saying, well, this was about the protection of the marine environment, that is not likely to be accepted as a justification. So that does apply to this case. This rather prolonged discussion on the issue of bunkering was to demonstrate that the legal regime of the EEZ is quite different from territorial on land or even the legal regime of the territorial sea, which is a legal regime in the law of the sea. And also that the implementation of the regime may give rise to certain difficulties because it's based on the balance. And if you start talking about balance, there can be a kind of a tipping of balances in some situation. But I would say it is crucially important that this delicate balance is reflected in UNCLOS is maintained, as it has served to maintain stability for the legal order at sea by establishing a perhaps delicate balance, but a very useful way of accommodating the different interests that coastal states have in the utilization of the sea. And this was what was achieved in the Third United Nations Conference on the Law of the Sea. It took a very long time to achieve this compromise, but now we have this, and this is serving the basis for a certain part of the sea, which is not very small area because it extends to 200 nautical miles. And I think it's also worth noting that the two cases were settled by the International Tribunal for the Law of the Sea, and also that the judgment of the tribunal in the two cases, because of the judgments, we now have a better understanding of the scope of the rights that coastal states have to regulate bunkering in the exclusive economic zone. So now the reference to the role of courts brings us to another feature of the law of the sea, that UNCLOS has its own mechanism for settling disputes concerning its interpretation and application. And a significant feature of the UNCLOS dispute settlement system is that it has a compulsory element, meaning that although there are certain limitations and exceptions, disputes concerning the interpretation or application of UNCLOS are subject to procedures entailing binding decisions. So in short, if you have a dispute concerning UNCLOS, it could be referred unilaterally to an international court or tribunal without the consent of the other party to the dispute. And the reason that UNCLOS adopts such a mechanism is that UNCLOS was adopted as a package deal, as a product of years of complex negotiations, and in addition to not allowing reservations that could upset the balance of the entire convention, the dispute settlement mechanism was tasked with the role of preserving the integrity of the convention by providing a mechanism that could indicate a very objective understanding of how the convention should be applied and interpreted. And the courts and tribunals can play a very important role in maintaining the reflected convention, and this, I think we've already seen an example with respect to debunkering cases. If we are going to go into the procedural aspects of UNCLOS dispute settlement mechanism, it can appear to be fairly complex, especially if you're not familiar with this field, and especially if we try to put everything into one slide, which probably is not a good idea. It always drives my students crazy in my Law of the Sea class. But I think it does give us a good idea of how the UNCLOS dispute settlement mechanism works. Although I won't have the time to completely explain what is meant in this diagram, I think several important elements is worth noting and is worth highlighting. The first is that UNCLOS has a compulsory dispute settlement, which is what I referred to earlier. But it is also worth noting that UNCLOS dispute settlement mechanism also allows states to choose means of settling disputes. So if the disputing parties can reach an agreement on a certain method of resolving the dispute, that method will be used instead of the UNCLOS compulsory procedures. But if, however, if the states try that method, and if the dispute still cannot be resolved through the method, and if the parties had not agreed to exclude further procedures, then the dispute can still be brought to compulsory procedures. The second element is that UNCLOS provides a menu of courts and tribunals for states to choose from when invoking the compulsory procedures. On the slide, I think in the bottom, it is shown that parties can indicate their choice between 4 different international courts and tribunals. Between the ICJ, the International Tribunal for the Law of the Sea, ITLOS, Annex 7 arbitral tribunal under Annex 7 of UNCLOS, or a special arbitral tribunal under Article Annex 8 of UNCLOS. And if these states to a dispute have not chosen the same procedure, or if the state has not indicated its choice, the Annex 7 arbitral tribunal will have jurisdiction to hear the case. And this is why many of the important cases in the Law of the Sea have been brought to Annex 7 arbitral tribunals. Third, as I mentioned earlier, there are some limitations and exceptions. This fact is depicted on the right-hand side of the slide. Under Article 297, the compulsory procedures do not apply to disputes involving specific provisions relating to marine scientific research and fisheries, for which coastal states have some discretion to decide on certain issues. And also under Article 298, states have the right to declare that they will not accept compulsory procedures for certain types of disputes. And the specific types of disputes that can be excluded include disputes concerning maritime boundary limitations or those involving historic bays or titles, disputes concerning military activities, and disputes in respect of which the Security Council of the UN is exercising its functions. And overall, I believe it is fair to say that the existence of the compulsory dispute settlement procedure has contributed to the resolution of disputes concerning UNCLOS, and these cases, together with other cases concerning the Law of the Sea based on other bases of jurisdiction, such as the optional clause of the statute of the ICJ, they have contributed to the clarification and development of the rules contained in UNCLOS. And so now that we have covered some of the basic features of the Law of the Sea, I would like to move on to discuss some of the more recent developments in this field. First, I would like to discuss some fairly recent judgments that have made findings on rather important issues in the Law of the Sea. And then I would like to discuss the addition of a new important instrument to the Law of the Sea, which is the third implementing agreement to UNCLOS, often referred to as the BB&J agreement. And third, I would like to briefly discuss the ongoing procedure before ITLOS regarding the request for an advisory opinion in relation to states' obligations under UNCLOS in relation to climate change. So now, first on the issue of recent judgments, although again, I do not probably have the time to enter into a full discussion of the cases. If you have an interest in the law of the sea, and if you have not been keen in reading recent judgments, I would invite you to take a look at some of the recent judgments and awards. And I believe you'll find that many important issues have been addressed in recent years, especially perhaps in the period of maybe the past 5 years, which is something that may not be fully appreciated by experts who do not usually work in this field. So the list on the slide is just to give some examples, and I will briefly explain what each of the 4 cases are about. On the top of the list, we have the North Star case, which was decided by the ITLOS in 2019. And in that case, ITLOS made a very interesting finding on the scope of the exclusive flag state jurisdiction, stating that, and I have a quote on the slide, the tribunal said that the principle of flag state jurisdiction prohibits not only the exercise of enforcement jurisdiction on the high seas by states other than the flag state, but also the extension of their prescriptive jurisdiction to lawful activities conducted by foreign ships on the high seas. But there was, interestingly, a joint dissenting opinion by 6 judges on this point in this case. And I think it is very interesting to know that such a basic principle in the law of the sea, such as the principle of exclusive flag state jurisdiction, can still give rise to such a debate. And I think I found it very fascinating that we still have questions to answer on basic aspects of the law of the sea. Next, in 2021, there was a case between Somalia and Kenya, and this is not about the main issue that was discussed in the case, but in reaching a conclusion on the case, the ICJ indicated a very short but important finding in relation to the interpretation of Article 83.3 of UNCLOS, which is the obligation not to jeopardize or hamper the reaching of the final agreement when the states concerned do not have an agreement on the maritime boundary. And this obligation not to jeopardize or hamper the reaching of the final agreement is an obligation related to the actions of states in undelimited maritime areas. And the scope of this obligation has been subject to rather intense debate because the obligation is phrased in very general terms. You are under an obligation not to jeopardize or hamper the reaching of the final agreement. But would you violate this convention, this obligation, if you conduct certain activities in the undelimited maritime area? This was under intense debate. There had been 2 cases before the ICJ judgment on this issue. One was the Guyana versus Suriname case. The other was the case between Ghana and Cote d'Ivoire before a special chamber of ITLOS. And the two cases adopted a rather different approach, and there was a lot of discussion on which should be the appropriate approach to be followed. The ICJ basically followed the approach that was indicated in the Guyana versus Suriname case, which was actually being subject to certain criticisms in academic discussions, but the criteria adopted in that case was that activities that are of a kind that could lead to a physical change in the marine environment would violate the obligation. So the criterion is whether there is a physical change in the marine environment. And the ICJ adopted this criterion, although it did not even engage in discussion, sort of casually referred to Guyana, Suriname, and adopted the standard. But I still think this is rather important especially if you're in a state which has undelimited maritime areas, because this is about the obligation you have pending the delimitation of the maritime boundary. In the third case, which was decided in 2022, in the alleged violations of sovereign rights and maritime spaces in the Caribbean Sea case between Nicaragua and Colombia, the ICJ considered various issues, but I'm focusing on a rather specific issue, The court, in deciding this case, considered in detail whether straight baselines were validly drawn under the relevant rules of international law. And this is about Article 7 of UNCLOS, which allowed states to measure their maritime zones from baselines using straight lines. And many states, of course, have referred to this article in drawing straight baselines. Japan has a rather comprehensive set of straight baselines. I think other states also do. But there are certain conditions that must be fulfilled in order to be able to draw straight baselines on the basis of Article 7. And in practice, the requirements under Article 7 has been rather liberally interpreted. Maybe that's too much of a nice word, but that has been the case. And it was not the first time that this issue was discussed in an international court or tribunal. However, I think it's probably the first time the ICJ engaged in a rather rigorous discussion, rigorous scrutiny of whether a particular coastal configuration actually meets the requirement of Article 7. So basically, the situation we have with straight baselines is that between states is that you don't point to my straight baselines, then I won't point to your straight baselines. We have that kind of equilibrium in the international society. But I think it has been maybe unfortunately shown that if an issue is brought to a court, the court may go into a rigorous scrutiny of whether the requirements under Article 7 are actually met. And in the final decision that we have on the slide at the bottom, the judgment rendered actually in July, that's last month, is it? So in this year, in the case concerning the question of the limitation of the continental shelf between Nicaragua and Colombia beyond 200 nautical miles from the Nicaraguan coast, which is a rather long case name, this was between Nicaragua and Colombia. And in this case, there was a very, very important finding that the entitlement of a coastal state to a continental shelf beyond 200 nautical miles does not extend to within 200 nautical miles from another state. This was one of the remaining very, very big questions relating to the delimitation of the continental shelf. So you can have situations where you have distance-based continental shelves. Now I'm sort of starting to regret that I did not have a section on the continental shelf before. But you can have a situation where the 200 nautical mile continental shelves overlap, but you may be aware that in certain situations you can have a continental shelf extending to beyond 200 nautical miles. And that could, for example, overlap with the distance-based 200 nautical miles. In that situation, there is a question of whether the 200 nautical mile distance-based continental shelf automatically prevails, or should we regard it as still an overlap between the 200 continental shelf beyond 200 and the continental shelf within 200 nautical miles. So this was a very big issue. Actually, this is a very big issue for Japan because we do have such a situation in the East China Sea. But the ICJ decided in very definite terms and stated that, and I have the quotes from the relevant paragraph, the court concluded that under customary international law, a state's entitlement to a continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territory is measured may not extend within 200 nautical miles from the baseline of the other state. So this issue will have this finding will have a very big impact on maritime boundary delimitation, where you have a state that is claiming entitlement to the continental shelf beyond 200 and is overlapping with the 200 nautical miles continental shelf of another state. And as I mentioned, we do have such a situation here in Japan. Second, I would like to draw your attention to the fact that a new treaty on the law of the sea was adopted 2 months ago, and it will be open for signature next month. The official name of the treaty is the Agreement under the United Nations Convention on the Law of the Sea on the Conservation and Sustainable Use of Marine Biological Diversity of Areas Beyond National Jurisdiction. And since this is too long, it is often referred to as the BBNJ Agreement for short. The agreement was adopted to respond to a perceived gap in the legal regime that applies to the high seas and the area in relation to the conservation and sustainable use of marine biodiversity. On the one hand, if we look at UNCLOS, there are provisions on the protection of the marine environment, but only general provisions on the protection of the marine environment in general. And also, UNCLOS only contains limited rules on biodiversity because I think the concept of biodiversity was not discussed as much when UNCLOS was being negotiated. On the other hand, after UNCLOS, there was the adoption of the Convention on Biological Diversity, which is the convention specifically dealing with this issue of biodiversity. But this convention primarily applies to the components of biodiversity only within areas of national jurisdiction, which is up to the EEZ and continental shelf. So there was this argument that there is a gap, and although there existed specific treaties relating to activities on the high seas, such as treaties establishing regional fisheries management organizations, there was this argument that the lack of mechanisms for the coordination and relevant instruments for emerging bodies are a problem. And so the issue came to be discussed within the UN starting from 2004, I believe, and after nearly 20 years, the negotiation process for a new treaty came to a very successful end. And the treaty addresses four rather distinct issues relating to the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction. I will try to very briefly explain what this treaty is about. First, on the issue of marine genetic resources, which refer to genetic resources found at sea, which could be used to develop products such as pharmaceuticals and cosmetics. The treaty introduces rules relating to the access to these resources and introduces a system for the fair and equitable sharing of benefits arising from these resources. And this includes a scheme for the sharing of monetary benefits, which will be used to fund the financial mechanism that will be established under the agreement. Second, on the issue of what are referred to as areas-based management tools, which include marine protected areas, the treaty will allow the establishment of marine protected areas on the high seas. The area-based management tools and marine protected areas are now regarded as very effective tools in conserving and sustainably using marine biodiversity. However, under the existing legal regime, which is based on the freedom of the high seas, it was difficult to establish a marine protected area which is binding on a large number of states. So if the BBNJ agreement attracts a large number of parties, it will be possible under the agreement to bind states to regulation in a marine protected area. Third, on the issue of environmental impact assessments, the obligation to conduct environmental impact assessments is already contained in UNCLOS and also in customary international law, but this is put into a more detailed form. And finally, on the issue of capacity building and transferring technology, the agreement sets out obligations for states to cooperate in achieving the objectives of this agreement through capacity building and the development and transfer of marine science and marine technology. And while the BBNJ agreement might sound like a rather specific treaty, which is only limited in the geographic scope of application to the high seas and the area, it is expected to have a major impact on the law of the sea once it enters into force. In addition to the specific rules and mechanisms, such as on the benefit sharing or establishment of marine protected area, the agreement could have a revolutionary impact on how we perceive the areas beyond national jurisdiction. The agreement significantly diminishes the freedoms of the high seas, which had been a long-standing principle in the law of the sea, and effectively places the high seas and the area under international regulation. The agreement also reflects more recent principles which have been developing in the field of international environmental law relating to sustainability in international law, And since the agreement is considered to be consistent with the convention, the adopted principles actually may feed back into how UNCLOS is interpreted. And further, the agreement will have a conference of parties which will make decisions relating to the implementation of and the operation of this agreement, and we'll have various subsidiary bodies to support the COP. And such an institutional mechanism to support the operation of a treaty regime, which is often found in multilateral environment agreements, is something that we did not have in the law of the sea before, and this may contribute to the change in how issues relating to the law of the sea is discussed. And finally, and third and finally, with regard to recent developments, there is an ongoing proceeding before ITLOS concerning the request for an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law. You may be aware that there is another request which is submitted to the International Court of Justice, also relating to climate change, from the United Nations General Assembly. But the one submitted to ITLOS concerns the specific obligations of states under UNCLOS relating to climate change, and it asks two questions which are put on the slide. And it is basically about what are the specific obligations under UNCLOS relating to climate change and the impact of the climate change to the marine environment. And if we think about Part 12 of UNCLOS, which unfortunately, again, we did not have enough time to discuss, Part 12 of UNCLOS contains rules on the protection of the marine environment. It provides general obligations for states relating to the protection of the marine environment, such as in Article 192, which is a very general obligation. And Part 12 also contains more specific rules relating to the regulation of pollution of the marine environment. The term pollution of the marine environment is also defined in Article 1 of the Convention. And the concept, as defined in Article 1, the concept of the pollution of the marine environment may be broad enough to include greenhouse gas emissions, and it might be possible for the tribunal to elaborate obligations based on Article 207 or 212 of UNCLOS by categorizing greenhouse gas emissions as pollution from land-based sources or pollution from the atmosphere. The tribunal could also theoretically provide some details to the general obligations contained in Part 12, in the same way that the arbitral tribunal in the South China Sea case drew some specific obligations out of Article 192, which is on its text a very general obligation. And in that case, the arbitral tribunal considered that the corpus of international law relating to the environment informs the content of the general obligation in Article 192. So I think that is one approach the tribunal could possibly follow. But in any case, I think that whether the advisory opinion could persuasively provide detailed obligation, whether the advisory opinion would provide useful guidance for states will depend on whether the tribunal could persuasively provide detailed obligations from the provisions contained in Part 12. How this will unfold, I think, is a very big issue worth looking at. And with that, I've tried to reserve some time for Q&As, so I'm very sorry for speaking a little bit fast in the final parts of the discussion. But with that, I've reached the end of what I have prepared for the session. Unfortunately, it was beyond my capacity within the limited time available to provide a comprehensive overview of the two fields, the law of territory and law of the sea. However, I'm hoping that my presentation was able to give you some sense of the essence of the two areas of international law and what is currently happening in the law of the sea. So thank you very much for your attention. Thank you.